What's going on at the Appellate Division? Tune in for today's Legal Scoop. So the issue for this month's Legal Scoop is labor market attachment, which is something I think we're all familiar with. Everyone's got a case where either it's on for PPD and the claimant needs to demonstrate labor market attachment, or you've got a claimant who's no longer working for your employer who needs to demonstrate labor market attachment, and they send a ton of job search records into the board file. Jover v. Alba Demolition is this month's case, and it came down from the Third Department on October 30th of 2025, and it addressed this exact issue of labor market attachment. Basically, what happened here was we had a claimant who he was not an English language speaker, and his job history was basically in things like construction and sort of manual labor type jobs. And it was the time of PPD, permanency. He needed to prove labor market attachment, and he submitted plentiful records of job searches. And here's what's really interesting about this case. We all know that a claimant needs to prove that they're searching for work within their physical restrictions. It's a pretty common tenet in workers' comp. But they also need to demonstrate that they're looking for work that's consistent with just sort of their general vocational restrictions. So, for example, here, the claimant couldn't speak English, but he was applying for work where he would need to speak English. Additionally, the claimant, his job history, again, was primarily manual labor, but he was applying for positions where he needed highly technical specializations, including certain education, college degree, things like that. So you will have cases where a claimant will send a ton of job search records. That's not an automatic labor market attachment finding, and you should always refer to defense counsel to look through those records more closely and to see if, yes, this is actually legitimate labor market attachment evidence. So what did the court end up ruling? They affirmed the no labor market attachment finding because, frankly, the claimant's job search records, while extensive, were not valid. And the main reason they weren't valid was because he applied for positions that were within his physical restrictions, which would normally be labor market attachment, but that were not within his restrictions as far as his language capabilities and his specializations. Now, that doesn't mean that all claimants who can't speak English can't demonstrate labor market attachment, because most jobs in the United States would likely require some level of English language proficiency. It just means that the claimant needs to take additional steps to demonstrate attachment, and that might be taking English as second language courses along with participation in Workforce One, Access VR, something like that. What's the lesson for this? Well, don't roll over on labor market attachment. If you have a case where it's on to address that issue and the claimant produces a plethora of job search records, refer to defense counsel to look through them and determine whether it's actually a legitimate, good faith search for work, because you might have a valid defense of labor market attachment.